You try now.
In the old days, we would be here till 4 in the afternoon. And now I come out no, I mean, it would take all day, but then they get the essays. I put it this way.
Oh, it's just over. We're talking about it. They must have been waiting.
I appreciate it. No, we good.
But it was.
That's nice.
Yeah.
Maybe he's preparing for when.
So, yeah, all day
Can we do a sound check for the people who are online? Steve?
Yeah. Yeah, now I can only control what I can control.
Can we check sound?
You can check, yeah.
Okay, can the people who are online, Dr. Christine, Dr. Drake, Dr. Kerrigan, Mr. Parsons, can you all hear me?
Yes.
Okay, great. And just a reminder that when you vote, you need to go on and off the mute so that we can hear you when you're voting.
Okay.
Thank you.
Don't expect me to. Still have reports.
expectations on them.
Do that before, but it's the formatting issue, that's the.
Yeah. It's the biggest pain. It's got-
So now I finally figured that out. It's filled in, so it's, otherwise it'd be figuring it out.
Live streams.
We use area 10. Got that down. I thought they were here.
There's some AirPods here that I don't know to whom they belong, but they're not Dr. Barnes. If it's anybody's, right, they were
They are.
down on the floor.
If they connect to my phone, then I know they're mine. Yeah, that was. Yeah, they were. They found them on.
The rightful owner has collected his AirPods from them.
Yes, I brought them in. Can you hear me? Nope.
See, do you have to do anything with this lavalier to get it going, or do we have the sound coming out? Cause I don't hear myself from the.
Testing, testing. Remember, the mic is on a minute.
Hello.
It was working a minute ago.
We're waiting to get Dr. Barnard's lavalier working fully, so just give us a second.
Do you wanna just start with this? And I'll take care of it.
Yes, we need to, take a look here. All right, good morning. We're going to call to order the meeting on July 31st, 2026 at 9:06 a.m. First item is the agenda roll call. Please answer here. Dr. Bazzini?
Here.
Dr. Coble?
Here.
Dr. Mitchell?
Here.
Dr. Drake?
Here.
Dr. Kerrigan?
Here.
Jarvis Parsons?
Here.
Erica Zemak?
Here.
Due to a reported conflict, Mr. Daniel is unable to present at the meeting today. Is there a motion to excuse Mr. Daniel's absence?
I personally do not excuse his absence and want to know him severely fined
We got to go
and
through this.
imprisoned.
Has the motion been made?
Second.
All right, is there a second? All right, all those in favor say aye.
Aye.
It's been approved. We'll chastise Mr. Daniel the next time he's back. Item number 2. Have you reviewed and adopted, and we've got to adopt the minutes. Is there a motion or is there any discussion on the minutes? Hearing none, is there a motion to accept and adopt the minutes?
Move to approve.
Second,
Second.
Second.
all those in favor say aye.
Aye.
Opposed? Motion carries. Item number 3 is the office administrative update.
We have an updated budget in your materials. That's the budget status report, which we do every quarter. And then we also wanted to talk to you about 2 more things. One is office construction. We took Ms. Zemak and Dr. Stout through our new office space yesterday and showed them everything. It's now at like punch list, final work is being done on the office. Technically, I think we're not supposed to go over there until we install the furniture, which there's a little bit of a delay from the corrections industry furniture supplier. But we should have the furniture by the end of August, at which point we'll be able to move in. The space is wonderful, it's expanded, it's really nice. So thank you to OCLW for kicking us out of our old space, because now we have better, bigger and newer space. It took a little while, but we're almost there. And then the other thing that Chelsea did was she took a look at OCFW's signage, which is really nice, a big, beautifully done sign, and we're gonna order some official signage and we'll have a little reception area. There's a place called the huddle room for commissioners. So when you come in, if you wanna do calls, same thing for lab directors, if you're here early, or anyone who comes to the meeting and you need space to work out of, we'll have that. We have a little conference room. So we're really happy about the new space, and we'll probably do a little grand opening type thing at our next meeting, so we'll add that to the agenda. And then Lee was gonna report on a change that has happened on further development of the ALIS functionality for labs. So do you wanna talk about that a little bit?
Sure, so we launched recently the Crime Laboratory Director and Quality Manager function in our ALIS or ALIS database. I'm not really exactly sure how to pronounce it, but I think it is ALIS. The function basically allows laboratories to submit anything you would normally email to the Forensic Science Commission. So like your licensee change forms, your proficiency monitoring forms. For de minimis labs like NMS, if you're sending us an updated spreadsheet and you want to make changes to the way some of the licensees appear online, that's basically the way you'll tell us. And the benefit of that is that we have a tracking method for all of the requests that come through rather than just requests into the inbox. And we're able to get you all notification once we process it. It sends a little email that says your application's been approved. And so if you have any comments on that or any suggestions for us, we're always happy to get feedback. We've been able to improve the licensing side of it, things for individual applicants, because we've gotten so much good feedback from you all and from the licensees. I think that's it for the update on that.
That's all we have for item 3.
Well, Item 4 is an EPIC complaint and disclosure list today that Mr. Daniel conveniently is unable to attend. So staff will present these and we'll get started on it.
And we're gonna be, we divided this very large list up, between folks, and we may not get through as fast as Mr. Daniel, but we'll try, so. Okay, Jared, you're leading us off, correct?
Dr. Barnard is staring at me, so I'm gonna try to be informative and brief at the same time. We'll see how that goes. So this first self-disclosure is 26.14 from Bodie Technology, and this self-disclosure is carried over from the April quarterly. So just quickly recall from your materials that this just involved some concerns that were disclosed by legal stakeholders after a trial verdict but before sentencing. And so the laboratory looked into, in this particular case, how they assigned a number of contributors to a complex mixture that revolved related people, and then also the analyst's explanation of the likelihood ratio during testimony. Bodie has already completed several corrective actions to date, including amending reports, training the analysts additionally on testimony and a testimony correction report, and then also some laboratory procedure updates for interpreting these challenging mixtures. So where we stand right now is that Bodie has started their review of Texas-related casework, which really applies to the DPS CAP lab. For the prior 2 years to identify potentially impacted cases. Of 328 total cases between January 2024 and April 2026, they've identified 5 cases that potentially fit into this complex DNA mixture / related contributors issue, I guess, or challenge. They have not completed that review yet, but anticipate being done with that hopefully in time for the October meeting. So we don't really have any additional updates per se, but they are working on doing that retroactive review right now. And so therefore, staff would like to recommend tabling the self-disclosure pending the completion of this Texas-specific case review.
All right, is there a motion to table this final conclusion regarding this complaint?
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Great, okay, moving on to the next self-disclosure, it's 26.09 from the Center for Human Identification relating to forensic biology and DNA. There will be a recusal here for Dr. Coble and Nasima. So for this incident, in early March, the CHI reported an incident in early February, and its missing persons unit related to the processing of family reference samples. Essentially, an individual failed to follow their procedure and how they were amplifying reagent blanks in their batches. They were supposed to do the reagent blank check prior to the batch. When the individual was questioned about that incident that day, she essentially panicked and misrepresented her actions and left for the day. Later that evening, she ended up submitting a resignation to her supervisor that would be in effect for a couple weeks later. She ended up coming back to work after taking the next day off and had a discussion with laboratory management and admitted, as she read from a prepared written statement, that she didn't actually perform some of the things that she said she performed, and that she ended up performing that amplification step concurrently with the reagent blank and the remainder of the samples instead of doing that check ahead of time. And that is where she admitted that she panicked and left for the day. This scientist was off-boarded that day. The laboratory has since done some work and submitted a corrective action report, which is in the materials. And even though she did have some prior quality incidents, when the laboratory reviewed those, they found that they took sufficient action and that there wasn't any flags that were raised about her credibility that would really lend to this instance where she essentially panicked. They also reviewed her previous involvement in casework. She's not an interpreting DNA analyst, so she has a role in performing different laboratory steps, but it's usually just one sort of cog in that wheel. There were always other people involved in those steps and technical review as well. The samples in that particular impacted batch were re-extracted, and that was what was reported out, and the laboratory putting that corrective action report in all impacted cases for that batch. And then due to the nature of missing persons cases, they're not always criminal. So the lab definitely has a plan to handle those notifications if hits arise or if they're expected to be involved in some sort of criminal investigation. So with that being said, there really wasn't much else to do since the individual has departed the lab in terms of getting to the root of that cause for the incident. So this does potentially fall into some areas for staff investigations. So the staff does recommend that the commission accept this self-disclosure for staff investigation under, I'm gonna butcher this legal stuff, Lynn, under 37 Texas Administrative Code, section 651.307D, to determine whether the laboratory's assessment of potential professional misconduct for failing to include this contamination, essentially following procedures, warrants disciplinary action by the commission.
All right, a recommendation for accepting this for investigation has been made. Is there a motion?
I'll make the motion.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Number 3.
Okay, don't get mad at me,
This
Dr.
one's
Barner.
gonna be a little longer.
This one's hard, and I'm going to try to present this one equally as efficient as the first two have been. So 26.10 is a self-disclosure out of Corpus Christi Police Department involving their firearms unit. Again, there was extensive materials or documents in your materials involving this, and long story short, this is the investigations and corrective actions are gonna be ongoing here, but this is complex because of this firearms unit, there's only 2 firearms examiners, or were, and now there are not any. And so, as part of this process, the laboratory has removed firearms from their scope of accreditation, and they are engaged in an extensive case review, corrective action, and then, of course, with hopefully a goal towards staffing stabilization, which just means standing the program back up again. So, a few facts here to consider, relating to Examiner 1, because like I said, there's 2 individuals involved here from this firearms section. An issue was caught during technical review where there was potentially a false inclusion or an erroneous false positive identification of a fired cartridge case to a firearm. This situation was a little complex because this firearm was not functioning correctly, so the individual made a cast to do their comparisons, but what they ended up doing was failing to look at some class characteristics, which would have immediately led to an exclusion here. Management noticed the issue and wanted to have conversations with this individual. They wanted to ensure that there was, address the potential causes of the non-conforming work, and specifically the fact that they didn't evaluate those class characteristics before moving on to the individual ones. So they removed him from casework. This individual then retired. And so then what this left the laboratory in was a little bit of a lurch. They only now have 1 examiner. And so they were gonna need to send out those technical reviews and verifications to DPS. And so what they found there was also potential issues with Examiner 2's work. To date, at least a couple incidents involving that second examiner's work have led to the issuance of corrective action reports, which means that they also need to essentially evaluate the extent of impact on that second individual's work. So now they've contracted out work with SCL Forensics to conduct case reviews not only for the first examiner, but also for the second examiner. And they are in the process of doing that right now. That's really the long and short of that process.
We
wanna
went
add
to
anything, Lynn?
the laboratory yesterday and they let us know that the consultant who's doing the retroactive case review has looked at the files. There are some challenges around completeness of documentation, which can make it difficult for her to assess which cases may need to be flagged, but she has identified a few that she believes where the evidence itself needs to be sent for re-examination. So My guess is those will go to Texas DPS. DPS, I just wanna put this out there on the record, has put their Laredo lab and Weslaco, they're both helping out. And, you know, as everyone who's here knows, firearms in general, I'm talking about at all labs, there are some capacity issues. We need to build the workforce and firearms examination, which right now, you know, it's a long training process, and so that's something we'll talk about later in the context of the apprenticeship program, but DPS has taken on the verification work, they're taking on, I believe, all casework that Corpus otherwise would have been performing when they had firearms comparison on their scope of accreditation. So it's a real service that DPS is doing for the community there in Corpus. I just wanted to make sure that we recognize that. So once we have more information about the review that's being done by the consultants, we'll be able to come back and talk through that. One of the issues that came up during our call yesterday is that the firearms work is no longer under their scope of accreditation. They are still accredited by ANAB for other forensic disciplines. So what we want to talk to ANAB about, and we'll be reaching out to them soon, is what they would want to see in terms of corrective actions and root cause and so on. Given that it's no longer on their scope, would that only kick in were they to seek to put it back on the scope? Because now they don't have fire. Scope, obviously. So I don't have anything else about this except to say that it is rare that we have something that comes off the scope due to concerns about quality issues. Typically when there's movement on a scope, it's more like, you know, we don't have enough casework to sustain this discipline, or we've lost examiners for basic attrition, and so we're gonna pull it off the scope. So this is something that the lab is taking seriously, and it will take some time to get through the work that they're doing.
All right, well, this kind of highlights the issue that keeps coming up about cartridge cases. You may have been the initiator on this, but it's an issue that has to be addressed. So the recommendation is to table this. Is there a motion?
So moved.
All right, so motion, is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
Okay, next we have self-disclosure 26.17 from Bexar County Criminal Investigation Laboratory and their seized drug unit. April 1st, Bexar County reported an incident there where an analyst documented macroscopic and microscopic examinations of green plant-like material without actually performing the tests required to make those observations. The laboratory discovered this error during technical review. Technical reviewer noted that there was missing documentation in the LIMS worksheet about this and returned it to the analyst. The analyst then proceeded to continue that review, noting that the required examinations were complete and the LIMS worksheet had been updated. However, upon verification, the reviewer discovered that only one evidence seal on the item, meaning that there was no way that the analyst could have gone back in to look at that evidence again. So what that, and that means the analyst would have documented those findings without actually conducting the examination. When this analyst was questioned about this, she recalled performing the examinations during the initial examination, but simply just failed to document them in the LIMS worksheet. This analyst further stated that that's essentially what she always does. It's part of her regular process, so she must have done it this time. And that she would only give the description of green plant-like material if she would have actually performed a micro or a macro examination. So also in this case, a complicating factor is that the analyst appears to have failed to also perform one of these types of macro-micro examinations on another item in the case. cited visibility due to some pink packaging here, but when they went back to look at this in the presence of the analysts, the packaging was translucent enough that you could clearly see the plant material. So that note also didn't substantiate the analyst's explanation about not doing the examination on the other item in the same case. So essentially, the laboratory determined that the analyst violated an accreditation requirement 3125 7.5.1, which requires the documentation of original observations and data to be recorded at the time that they are made. And since she did not record that documentation at the time, the seal issue, the laboratory felt confident in that. More conversations in April. The laboratory issued a memoranda suspending the analyst's authorizations for independent casework due to this nonconformity. A few days later, the quality assurance manager conducted an audit of the analyst's in-custody cases. There were no other issues found. And they also did a couple other queries and have not found any other additional issues with their casework. The laboratory has notified all the stakeholders, and has implemented a check for proper labeling during the casework observation portion as part of their internal audits in the future. They do believe that the issues were isolated and the analyst is currently undergoing retraining. So the staff here recommends to accept this self-disclosure for staff investigation under chapter 37? 37 Texas Administrative Code.
Texas Administrative.
Section 651.307D to determine whether the analyst's conduct constitutes professional negligence or misconduct and to assess whether the conduct merits any disciplinary action by the commission.
All right, the recommendation's been to accept the disclosure for investigation. Is there a motion?
Oops.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. The next I will have to recuse myself, so Dr. Drake, you'll have to run the vote on this.
Yes, okay, so this next one is self-disclosure 26.19 from the Southwestern Institute of Forensic Sciences in their forensic biology DNA section. So recall from, I'm not sure if it was last meeting, because time flies, but the incident with analyst Kenneth Balagot in the biology section here at SWIFS. One of the corrective actions from that incident was for the laboratory to conduct a review of the electronic or that raw DNA data against the case file in preparation for testimony. So unfortunately, this incident came out of that. While preparing for trial, the laboratory found a discrepancy between the technical data records and the documentation for a DNA standards batch, which again is a known reference type sample by a former analyst who is no longer employed by SWIFS. So this case can essentially be boiled down to work that was performed during the process but not documented. So the very first injection on this batch for this DNA profile showed some potential peaks below threshold in a reagent blank. The analyst didn't go to her technical management. That's not necessarily required, but it is business practice in that section. So she proceeded to do a re-injection of that same blank, and it had more indication of reagent blank contamination in that second injection. So then what she went to do was re-prepare that injection and run it for a third time. So what ended up happening was the quality control packet that this individual submitted for technical review only included that first run and the third run, but it didn't include the second run. So what SWIFS asserts that the analyst failed to follow laboratory process or policy in a few areas. Again, like I mentioned before, potentially not notifying the technical leader of the reagent blank contamination. No one knew about the contamination, so there was no way for them to be able to track that. To document the event with the required form, and to create a troubleshooting packet that would document all of the steps taken to help remediate that potential contamination of the blank. SWIFS sent this former analyst a letter detailing their preliminary assessment, including a timeline and description of the events and an explanation that the failure to fully document the troubleshooting events is disclosable under Brady and Michael Morton Act 39.14H. Their letter further extended the analyst an opportunity to provide additional information, but the analyst did not respond. SWIFT has added an adverse event form to all of the affected cases within this batch, and they notified their Dallas County DA's office. And SWIFT has indicated that former analysts may have committed professional misconduct by intentionally failing to disclose this analytical work, especially in light of potential testimony given related to this case. Staff has requested a transcript from this trial, but we have yet to receive that. But what we can do now is recommend that we accept this self-disclosure for staff investigation under 37 Texas Administrative Code Section 651.307D to determine whether the laboratory's assessment of professional misconduct for failing to include this documentation for reagent blank contamination in the case file warrants disciplinary action by the commission.
We have a staff recommendation to accept the self-disclosure for staff investigation. Can I have that in the form of a motion?
So moved.
Okay. Do we have a second?
Second.
Okay. All in favor, say aye.
Aye.
All opposed? The ayes have it. The motion carries.
All right.
Okay, moving along to the next self-disclosure, 26.39 from Bexar County Criminal Investigation Laboratory in their materials trace section. Here at the end of May, Bexar County reported an incident where an evidence technician mislabeled and switched evidence during the evidence intake or evidence login process. The investigation determined that one of the containers in a case number 1 was labeled with the information from another container under a different case, that these two items or cases were submitted at the same time by San Antonio Police Department. And so what happened was you just had discrepant information on the containers versus what the internal laboratory's labels would be for that evidence. This discrepancy was noted during the analysis by the examiner, and a comment was placed in the report. However, it was reported out without verification of the correct case identifiers because this was a rush case, which absolutely impacted, I think, how this case was handled. So once the error was confirmed, the laboratory immediately notified the district attorney's office and worked to handle the sending out amended reports. They added references to the corrective actions for both of the reports that were sent out, and essentially felt like they already had the processes in place in their labs because they documented the discrepancy, noted it in the report to see this, but this was a little bit of a special case because there was a rush request on one of these cases that led to reporting this out. So it appears to staff that this has been handled well by the laboratory, and that they already have the processes in place and that they acted quickly to remediate. So we, at this time, recommend that the commission take no further action on the self-disclosure based upon the actions taken by the laboratory.
All right, a recommendation for no further action has been made. Is there a motion?
So moved.
Moved.
Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries. Number 7.
Okay, this is my last one, but not the last one.
Yeah.
So this self-disclosure 26.45 is from the Serological Research Institute relating to forensic biology and DNA. So in early April, SERI disclosed the ongoing instances of DNA contamination for their fired shell casings extraction process. So essentially here, what happened is that the laboratory up till this time with their method was able to combine up to 13 extracts. So that's 13 separate DNA extracts and then 13 separate accompanying reagent blend extracts. Through this process, they noted a spike in their contamination of their reagent blanks in early 2025. And this was something that ANAB noted during a surveillance assessment. And then they had proceeded to notify us of this situation. So they took several actions to help investigate what would be causing this spike in DNA contamination, including looking at how they concentrate or combine their samples, the methods they use, whether they poured or pipetted, looking at their extraction buffers, and then just the cleanliness of their extraction room. As part of this evaluation, Siri decided to reduce the number of extracts that they could combine down from 13 to 6 and continue to monitor the impact of that on their ability to detect potential contamination or not. They also identified a potential source of contamination with one of the extraction buffers that they received from QIAGEN. They were using a large stock bottle of G2, for those that are familiar with that buffer that used with that process, as opposed to smaller bottles of extraction buffer that actually come with the Easy 1/2 kits. And they found that those were being treated differently by the manufacturer. And so they made the decision to only use the G2 buffer that comes with the kits themselves, or if they're gonna use the larger stock bottles, that they need to essentially maximize the amount of volume that they would be dealing with during the extraction process for a QC, and to not have any indications of allelic data in their reagent blanks after taking that through the process. So what they did after these changes was decided to monitor the next 10 cases for casings extractions, but I think it should be noted, they're actually monitoring every case they're doing right now with the reagent blanks. And they did not observe any peaks on the reagent blanks for the listed cases on the correction actions form, and they also provided us an Excel spreadsheet that detailed, the outcome of really all of their events. And what I went through that and just noted that they're really often pooling fewer than 6 extracts together, which I think is probably fair. And their instances of potential contamination have been reduced significantly. I've also been in communication with the laboratory, and they're going to continue monitoring contamination for this method because they are combining multiple extracts together. Therefore, the staff recommends the commission take no further action on the self-disclosure given their root cause analysis and their corrective actions and their commitment to ongoing monitoring of their casework.
All right, a recommendation has been made for no further action. Is there a motion?
So moved.
Is there a second?
Second.
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
So the next 5 self-disclosures will conclude our self-disclosures portion of the complaint screening, and they're all related to missing, impacted, lost, or destroyed evidence. So we grouped those together for you all. The first one here, number 8 on our agenda, 2620, is a reported self-disclosure from Harris County Institute for Forensic Science, where a small fire occurred inside the firearms identification laboratory. And because of that, the laboratory sprinkler system activated to essentially suppress the fire, which led to some extensive water damage to the area of the firearms lab. No actual case files were affected by the water damage, except for some of the paper files that they still have in the laboratory. They did report damage to 3 instruments that the lab immediately removed from service and replaced. Each affected case that had those paper files had either been completed or reported or had been completed and was awaiting technical review. So the lab added an individualized memo to each of those case files detailing which documents they reprinted or recreated, and identified the original dates of the review or the reviewer. They implemented some corrective actions as well. They pulled all paper copies from firearms case files of archives, and they digitized those. They do have a plan in the future to fully digitize everything in their file system, but of course that takes time, money, development, and implementation. In Fire Marshal's office in Harris County, HCIFS handled the fire safety corrective action by issuing a new agency-wide policy that requires the use of approved appliances, only in addition to rules about where they're plugged in a certain section of the lab, I believe. And furthermore, the fire marshal also plans to conduct a follow-up inspection of the lab until they feel satisfied that the employees are all adhering to the new safety policies and things are plugged in the appropriate spots. So in this instance, staff is recommending that the commission take no further action on the self-disclosure based on what the lab has done as far as identifying root cause, their own case review, including evaluation of any impact on evidence, which they determined none, and associated case records and other corrective actions by the lab.
Okay, well, on the plus side, at least the sprinkler system worked,
Yeah.
so that's a plus.
Did what it was
A
supposed
little
to do.
too well.
All right, recommendation has been made for no further action. Is there a motion?
So moved.
Is there a second?
Second?
All those in favor say aye.
Aye.
Opposed? Motion carries.
Alright, the next of these five, missing evidence self-disclosures is number 2628, and this is a DPS Westlaco evidence disclosure that's related to their forensic biology section there. An analyst in this instance heard the alarm sounding in the DNA walk-in freezer and noticed that the thermometer monitoring the inside was reading at a temp that was out of range, that's acceptable. The freezer is considered to have acceptable performance if it maintains a temp below 0 degrees Celsius, and the walk-in freezer contains already processed DNA extracts that are required by policy just to be stored in either frozen or in temp-controlled environment. The thermometer records indicated that the freezer stopped cooling on a certain date, Saturday, May 2nd, 2026, around midnight or so, and the lab manager was notified of that Monday morning and was able to schedule like a same-day repair where the vendor came in to assess what happened. The lab performed its own cause investigation and identified the failure of both the main and redundant compressors, which led to an unexpected freon leak and loss of cooling of the freezer. The temperature monitoring notifications also in this instance, the lab notes here that they were missed, and staff were sent email notifications on Saturday evening, acknowledged them without realizing that this would turn off any additional notifications that actually came later for out of range temps. To correct the issue, both compressor units were replaced by the lab and the freezer resumed operation immediately the following Monday, which was May 2nd. And the lab plans to purchase a monitoring system that has visual monitoring and alarms to indicate when one compressor is down, and also to implement a communication response plan for notifications received during non-business hours. Customers were notified since all DNA testing was completed, but a reference to the quality incident was added to each case file. And so staff in this instance is recommending that the commission take no further action based on the actions that the lab has taken and the associated case record documentations.
Brady, was this a freezer that was past its replacement date?
I don't believe so. So I think it was just a freezer that's there within our building that was not operating optimally during that weekend.
Yeah, I mean, we've all been through those where you're trying to replace something, you don't get funding, they won't fund it. That's a good explanation for why it should be replaced if it was on that list. All right, the
Warm in Westlaco too. It's pretty warm in Westlaco.
Yeah, well, it's very hot there. Recommendation for no further action has been made. Is there a motion?
So moved.
Second?
Again.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Alright, number 2629 is up next. This is DPS Austin evidence disclosure. The lab reported an evidence technician accidentally destroyed toxicological evidence, which was a blood kit, before the authorized destruction date. On one of the more recent versions of their destruction authorization form, the authorization date is listed at the bottom right section of the form. The form submitted by the lab appeared to be an older form where the authorized destruction date is listed actually in the middle of the form. And the judge's signature date is located at the bottom right corner where the technician would have expected the other date to appear. So the technicians, of course, failed to realize that the actual authorized destruction date listed was December 4th because it was in that middle section and not the bottom right section where they were going to expect it to be. The lab observed there were no corrective actions to the impacted case due to its destruction, and the LIMS record reflects what happened. the date of destruction through the chain of custody. The lab added a reference number to the lab's quality incident that they wrote up on this instance. And on May 29, 2026, the evidence team lead asked technicians to, going forward, highlight the latest date listed on any destruction form so that it's clear which date should be entered into the case activity in LEMS, so that they know what the appropriate destruction date is. The lab also sent a reminder to second reviewers, because this was missed by the technical reviewer, that they really should be reviewing every single item on the form, including the destruction dates and whether those were properly identified, and correct any that aren't. The evidence team supervisor at the lab emailed the affected county or case where the case was held, which was Hardin County. They emailed the clerk there to notify them of the destruction of the evidence, and the lab notified the district clerk also via email. And the lab further sent an email to the DA's office to request information regarding the impacted case, and the DA's office responded that there was no impact to the case. And so staff in this instance is recommending that the commission take no further action based on the actions that the lab has taken and their root cause analysis.
All right, is there a motion to take no further action?
So moved.
Is there a second?
Second?
All those in favor say aye.
Aye.
Opposed? Motion carries.
Alright, and the next one here, DPS Lubbock disclosed an incident that's evidentiary as well, and they reported that a firearms analyst discovered that they had lost an item of evidence that was a projectile fragment. The forensic specialist had submitted evidence from an officer-involved shooting, and the evidence package included item number CG16, which was that projectile fragment. According to the submission form, the police department said that they did package the projectile fragment in a 12 by 15 yellow envelope with multiple other items of evidence that were related to the case, with each item packaged in an individual smaller yellow sealed envelope inside the big one. And when the firearms analyst opened the envelope, once it was received at DPS, he couldn't locate that little projectile fragment that was indicated on the form that it should be part of the package. The analyst then contacted the submitting agency regarding the discrepancy, and the agency stated that based on the police department's practice, they felt really confident that the bullet fragment was in the evidence envelope when they sealed it and submitted it to the lab. The analyst did proceed to complete the analysis with the remaining evidence in the case. The analyst stated that also when they got the envelope, it seemed to be perfectly sealed, and the items in it were as indicated except for this little projectile, a very small projectile fragment that wasn't in the package and should have been. The submitting agency also said that the fragment was indeed very small, and it was approximately only 7 millimeters by 9 millimeters. And the lab just ultimately was unable to determine who lost the particular item of evidence. They indicated in the file that the particular piece of evidence that was missing is just not present, and that the envelope is empty. And in this matter, the staff is recommending that the commission take no further action based on the root cause analysis that the lab can't find the evidence, but they appropriately documented the missing evidence in the case file and did what they could there.
Okay, is there any discussion on this? Hearing none. Is there a motion to take no further action? Is there a second?
Second?
All those in favor say aye.
Aye.
Opposed? Motion carries.
Alright, this is the final self-disclosure. This is from Austin Forensic Science. They reported an incident in their seized drugs section where an analyst during a biennial audit that happened this year, they identified discrepancies involving a particular reference standard, methanolone acetate. Lab records indicated that the lab got the reference material, verified it, logged it, and approved it in May 2024 following its purchase to support an analysis in a particular case that they identified in their disclosure. The lab subsequently used the reference material in the analysis of evidence for that, only for that particular case, and then issued a report the following July 2024. The audit revealed, however, that after the standard's initial verification, the lab just failed to reweigh and re-enter that material into its own reference system and logbook that's really required by lab policy. In addition, staff omitted it from Seeds Drugs reference material inventory that they maintain in SharePoint as well. So they kind of missed the electronic documentation of it and didn't document its storage location at all according to policy. Consequently, the lab logbook records indicated that the material just remained checked out with that particular examiner that performed the initial analysis, which was the reason they had obtained the reference material in the first place. Upon discovering the discrepancies, the lab personnel conducted a search to try to find it, but they just couldn't find it at the requesting analyst's workstation. The lab believes the missing reference material really had no impact to the quality of the particular case for which it was used, nor any other casework, because it was never actually used again. The analysts verified the reference material before they performed any testing with it as well. And because the lab didn't catalog the material, analysts were just unaware that they had the reference material, so they know that no one used it. The lab did not notify any stakeholders since they determined that there was no impact and that it wasn't used in any other instance. Yesterday, the lab actually sent us a very detailed and thorough plan that they have been through in their Seeds Drugs section that included a finalized corrective action that's added to y'all's meeting materials. Our scientific expert, Jara, and also Lynn went through those materials last night and felt that what they've done is sufficient. They've revised their Seeds Drugs reference manual practices and notified staff of how they should be documented electronically as soon as they're received. And the lab is also doing a 6-month monitoring period where they're targeting 0 nonconformities related to Seeds Drugs reference materials. And so in this instance, we originally were gonna table because we didn't have all the extra information, but we're recommending that the commission take no further action on this disclosure based on the materials that we have from the lab.
Is there any discussion, since this is recent material? All right, hearing none, is there a recommendation to take no further action?
So moved.
All right, we've had a motion, is there a second?
Second.
Second's been made, all those in favor say aye.
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 Opposed? Motion carries.
So you want me to continue?
No. Next
So
are
the
the
next, we
complaints.
have 22 complaints on our agenda, 12 of which are staff dismissals, which are typically, we'll go through them quicker, but the next 10, our staff, Lynn, Jara, and Robert are going to address for us.
Alright.
Just remember, Robert, that you have to get like right up on the mic. If you can't hear it above you, then it's not projecting. You gotta get super close, sorry.
2601 was a complaint filed by the Narrative Project. This was actually dismissed at the last quarterly meeting. It involves a complaint about the presence of an unidentified DNA. The laboratory submitted a very detailed response, which was reviewed by the scientific director, and it was dismissed for failure to allege professional negligence or misconduct, and because the evidence in the case was tested and the results were reported according to established protocols. That same day it was dismissed, the complainant sent a supplemental request regarding differential extractions, CODA submission questions, and the basis for limited support. This again was reviewed by the scientific director. There's no new allegations of professional negligence or misconduct. So our recommendation is to reject this request, to reconsider the allegations, as the supplemental request fails to identify any new evidence of professional negligence or misconduct.
Is there any discussion? All right, a recommendation for rejecting the complainant's request has been made. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
Okay, so the next complaint that we have comes from the Innocence Project, not the Texas one, but the National Innocence Project, and involves bite mark evidence and autopsy, and in this case, we obviously don't have jurisdiction over the autopsy, but if you all recall, those of you who were here, the commission did a major investigation and report on bite mark comparisons in the case of Stephen Mark Cheney. Following from that report, we did a more extensive review of bite mark cases. In this particular complaint 26.12, we had tabled it last time because I wanted to take a look at the actual testimony in the case. And in this particular case, there was no comparison. Courts in the cases of those defendants, the threshold requirement was that there needed to be a comparison attempted. So here, there's a discussion about a suspected bite mark, but they did not make a comparison attempt. And so in our review of this is that in order for, I think, the commission to review this case, it would have to expand the original scope of the bite mark review, which was limited to cases where there was an attempted comparison. So it's really a conversation for you all to decide. We don't really know, how many more complaints we might receive if there was not the sort of threshold criteria requiring a comparison to have been attempted. So we're not sure, but we wanted to make sure that you understood that the original scope was pretty clearly defined in cases of comparisons.
Yeah, I think that having it as it is the appropriate level, in my opinion, just because someone's attempting to make a comparison and identification versus an opinion where they think it appears to be a bite mark. Well, that's an opinion. And while I understand it's an opinion when they say they think that it matches someone, but that's more detailed. So at least we have a threshold right now versus it's pretty much open. Is there any further discussion?
I would say, just to give you a sense, it's in your materials, but the type of testimony would be, suspicious for a bite mark, injury consistent with a bite mark. But for the nurse's testimony, she could not say who bit or what the age of the bite would be. So child, adult, all those sorts of distinctions. And then secondly, the doctor who performed the autopsy identified bruises appearing to be bite marks. But there were no, the cause was not bite marks. It was blunt force head trauma, and of course we have no jurisdiction over autopsy findings.
Any further discussion? Hearing none, is there a motion to dismiss the complaint?
So moved.
Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
Our next complaint is 26.22 by Kendrick Wesley. He's alleging that blood results obtained by the laboratory conflict with blood alcohol results obtained at a hospital and at the Harris County Jail. He alleges storage and transportation issues and an unreasonable delay in conducting the analysis. The laboratory conducted an internal review focusing on the technical analysis, performance monitoring, and laboratory processes. Didn't identify any issues or discrepancies in their analytical process, the internal chain of custody, or performance monitoring program data. All quality controls, calibrators, and internal standards passed. There's no gaps in the chain of custody. Their opinion is the evidence samples were properly handled and the results were scientifically supported. As an aside, this may just be confusion because hospital tests are not going to match laboratory tests. They test two different things. So the recommendation is to dismiss the complaint for failure to allege professional negligence or misconduct related to forensic analysis of physical evidence.
All right, is there a discussion? Hearing none, motion, recommendation for dismissing the complaint has been made. Is there a motion?
So moved.
Motion's been made. Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
The next one is 26.23 by Gregory Steen. The complaint concerns the 2011 DNA mixture interpretation in this case and a notification he received regarding mixture interpretation protocols. We found out this case was actually reviewed by the Travis County Conviction Integrity Unit in the DNA Review Project, and they determined that DNA evidence was not material to his conviction. And our recommendation is to dismiss the complaint because the appropriate entities in Travis County are responsible for DNA mixture case evaluation determined the results are not material to conviction.
All right, is there any discussion? Okay, recommendation for dismissing the complaint has been made. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Next is 26.24 by Melissa Ann Valley Pease, alleging that the Austin Police Department failed to order a sexual assault kit as part of the autopsy on her daughter. It says the pathologist later collected a sexual assault kit several days after the original autopsy at the mother's request, but the detective ordered it not to be processed because it was collected by the mother. This is a suicide determination. There's no criminal investigation open. There's also an allegation that there's some blood swabs from the purported weapon that had not been tested. The laboratory advises the police had not requested the testing of the sexual assault kit. And our recommendation is to dismiss the complaint because law enforcement agency has not requested the testing of the evidence, and the commission has no jurisdiction to compel the agency to do so.
All right, recommendation to dismiss the complaint has been made. Is there a motion?
So moved.
Motion's been made. Second? Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
26.26 is a complaint by the Office of Capital and Forensic Risks. It's filed on behalf of Otis McCain, who was convicted of the killing of a police officer in 2021. The complaint alleges the police analyzed a cell phone that was seized during the arrest of the defendant and created a filtered Celebrite report or a tagged item report, which contains search items and web history artifacts regarding, among other things, a gun show in Round Rock, how to clean a Glock 40, a bunch of pictures of guns, a cache item related to the offense and the victim on a news article from a news site, and a cache image of a California police officer who was killed a week before his offense. The complaint alleges that these items were introduced at the punishment phase of the defendant's capital murder trial, and he did get the death penalty. And the complaint alleges that the detective did not explain the meaning of cache areas. According to the complaint, a significant portion of the functions that cell phones perform are not displayed on the screen and may be unknown to the user. These functions can leave behind forensic artifacts which will get downloaded during the forensic extractions. For example, phone apps and web browsers preemptively download images associated with content a user may access to load web pages and apps more quickly. This process is known as caching, and it's saved to the phone in an area referred to as the cache area. And according to the complaint, this can happen before a user sees the content. There's a digital expert who included a report along with the complaint, and he determined that the image of the California police officer was cached automatically by a stock news app, which was installed on the defendant's phone before he purchased it, and the defendant never opened it. The 40 or so images of guns were cached from a single search on how to take apart a Glock 9 by separate searches and saved images. The reported search for a gun show was a suggested and not followed drop-down search from Google, cataloged by the phone while the user was conducting a different Google search. The images related to the offense were cached when the user went to a news station website and clicked on a suggested link related to the offense, but there's no evidence that he viewed, downloaded, or saved the images. And of all those images of guns, none of those were saved or downloaded by the user, according to this defense expert. And it requests the commission to investigate the use of digital forensics in the case and make observations about the integrity or reliability of the methods used to identify best practices in the use of digital forensics and to issue other appropriate recommendations. And our recommendation is to accept the complaint for investigation and issue a report that contains those observations, best practices, and other relevant recommendations.
I have a question. Does this fall within our jurisdiction?
For the limited purposes, no negligence or misconduct evaluation, but we can issue recommendations and guidance on this particular discipline. And completely coincidentally, received a call from a former director of the District and County Attorneys Association who asked whether we issued any guidance. And was wondering if we could issue a report, and I said no, but there's something coming up on the agenda, and completely unrelated reason. It's about, using this technology in border counties and so on. So I think that the focus would be certainly on, what guidance is out there, work with DPS on it because they have people doing this work who can help us understand, I think it's like so many things in forensic science, it's like there's what the technology you can do and then what you represent about the significance and the limitations of what you're seeing when you perform the review. So that's the type of guidance.
Is there was this raised at a point on appeal or ineffective assistance or false testimony, any appellate error at all?
So we did speak with the DA's office on this, and they just closed, there's a writ that was filed and
The direct appeal's been done, and now they're in post-conviction litigation, and this is part of that post-conviction litigation.
it's part of the post-conviction litigation, but the direct appeal is done.
We don't even know if the court has ruled that this was actually true. The defense expert has said this, but we don't even know if the court is even going to agree with the defense expert's testimony in this particular case, or have the state conceded error on this particular point?
I don't believe the state has conceded error, no.
I guess I'm trying to figure out, so all we're going on is the defense expert's affidavit as to what is found in order to do a report on the limitations of cell phone extraction testimony?
We're not going on the defense's report at all. We're just letting you know what the complaint says. It's an allegation like any other allegation. We're not saying, Robert was going through what the report said, but we're not saying we agree with that. It's something that we would have to look at.
I guess the recommendation was to accept the complaint and issue a report containing the observations. But it seems to me that one, the courts have not even ruled on the case yet, and we even have an answer back from the state's expert or the detective as to reliability of the caches, or whether or not, I guess, who would be the person making the call on these particular images as to whether or not the defense expert's claim is even correct.
So we've asked the person who did the original analysis for a response. So we'll get, like we do for all of our investigations, we'll get the allegations, the response, and then we're going to need to consult with an external expert, and we'll go to the OSAC digital subcommittee, we'll go to DPS where they do a lot of this work, and we will, what we would do if you were to approve proceeding is issue some guidance on, there's SWIG DE documents that talk about these things. There's been a lot of work done in this area. And so the question is, like, what is the OSAC registry contain? What does SWIG-DE said? And so the idea would be to focus on, where does, if you're gonna do this type of work, where do you look to make sure that you are comporting with the practices that are advocated by the community as best practice?
All right, any further discussion? All right, a recommendation has been made to accept the complaint and issue a report containing observations regarding the integrity and reliability of forensic analysis and best practices. Is there a motion? Is
So moved.
there a second?
Second?
All those in favor say aye.
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 Opposed? Motion carries.
Alright, 26.38 is a complaint by Timothy Burnham. It concerns testing on GSR stubs that were taken from 2 masks recovered at a suspect's residence. The complaint alleges professional negligence or misconduct due to the 2-year delay in conducting the test. The complaint alleges this violates the DPS 4-hour rule. DPS provided a detailed response. This 4-hour policy referred to in the complaint applies to hand swabs that need to be collected within a 4-hour window because people wash their hands and shake hands and put them in and out of their pockets and so forth. But it does not apply to the testing of inanimate objects like these masks, and the policy does not require analysis within 4 hours. So the recommendation is to dismiss the complaint because the allegations regarding violation of DPS policy are unfounded. The limitation applies to hand stubs collected on living individuals, not inanimate objects.
All right, any discussion? Recommendation has been made to dismiss the complaint. Is there a motion?
So moved.
All right, is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Okay, I've got the next one. This is complaint 26.41 from Gary Mount. Defendant Gary Mount filed a complaint here alleging that the DNA analysis and the related testimony in the case was based on flawed expert testimony and evidence on vaginal swabs, perianal swabs, and other flawed analytical methods. Mount claimed that the first DNA result was proven to be a false positive, and the laboratory failed to complete a separate male from female DNA during differential extraction. The defendant also alleged that the state's expert fabricated the laboratory report and said something about him being the major contributor. Staff obtained the laboratory reports from Harris County Institute of Forensic Sciences related to this complaint, and I reviewed the materials. This review didn't reveal any issues with the forensic analysis or any of the methods, but were the reported statements made in the case. Furthermore, we're still ironing out our older cases that have gone through that DNA mixture review process, but we did ask the Harris County Public Defender's Office about this case, and it was reviewed and was present on the list. And they determined that there was sufficient evidence to convict the defendant without considering the DNA mixture analysis in this case. So therefore, the staff recommends that the commission dismiss the complaint because I reviewed the records and then also that those were supported, and then the recommendations by the DNA mixture review team.
All right, any discussion? The recommendation has been made to dismiss the complaint. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
Alright, 2647 is Stephen Backstrom. He's alleging that the same nurse, who does not name, presented notch testimony. Notch in the hymen as evidence of traumatic penetration injury, which is contrary to recent consensus standards in current guidance documents. Our recommendation is to table this complaint while we obtain and review the trial transcripts.
Okay, is there any further discussion? All right, motion has been made to table the complaint. Recommendation has been made to table the complaint. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Trying to get us through this here.
26.49 is a complaint by Donald Wilson concerning the 1995 comparison of the bullet recovered from autopsy and test fires from the submitted weapon. He alleges false testimony and that the analysis was incomplete. Our recommendation is to table this complaint, allow us time to obtain the technical data and the transcripts for review.
Okay, recommendation's been made to table this. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
All right, then we have 12 staff dismissals, which I'm gonna kind of group. The details are in your GC memo on each one. There's 5 autopsy-related complaints that we recommend be dismissed for lack of jurisdiction because the term forensic analysis does not include the portion of an autopsy conducted by medical examiners. Those complaints are 26.21, 26.25, 26.30, 26.34, and 26.35.
I have to recuse myself on 3-4. So if we can do them as a batch, Dr. Drake, would you take over?
Yes.
Oh, no, it's 26.4. Sorry, I can do this one. It was number 30, it was number 34, not .34, okay. All right, recommendation, I did have a question. On 26.30, where was the autopsy done if the report is not back from October 2025?
Where was the?
Yeah, she says she hasn't, is she waiting on the report?
She's waiting on the results.
So that means the report's not complete?
That's
They're
what it
probably
sounds
waiting,
like.
they're probably waiting on some additional testing.
Additional tests.
Okay, well,
Is that too long?
yeah, it's like too long for what I'd accept, but, so the recommendation has been made to dismiss, 26.21, 26.25, 26.30, 26.31, 26.33, and 26.34. Is there a motion? Motion.
moved.
So moved.
Is one of the numbers was wrong, I don't know if we get it.
Do what?
26.33, that's not until the next. Do you want me to just say the numbers?
Yeah, why don't you go through them since we're,
Staff's recommending that, the motion be to dismiss complaint numbers 2621, 2625, 2630, 2634, and 2635 due to lack of jurisdiction because the term forensic analysis doesn't include autopsy.
okay, like she said. Is there a motion? Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
We have 5 complaints that staff is recommending dismissal for failure to allege professional negligence and misconduct related to the forensic analysis of physical evidence. Those complaints are 26.31, 26.33, 26.36, 26.40, and 26.46.
All right, the recommendation has been made to dismiss based on the failure to allege professional negligence and misconduct for 26.31, 26.33, 26.35, oh, that was the other one, 26.36 and 26.40.
And
0.46. Is there a motion?
So moved.
Is there a second? All those in favor say aye.
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 Opposed? Motion carries.
We have 1 complaint, staff will dismiss because the testing was performed principally for the purposes of civil litigation and is outside the commission's jurisdiction. That is complaint 26.37.
Well, I think I can keep that one straight. Recommendation to dismiss 26.37 since it was used for civil litigations outside the commission's jurisdiction. Is there a motion?
So moved.
Second? All those in favor say aye.
Aye.
I had was there going to be discussion on this one? I understand it's outside of jurisdiction, but I feel like this is an issue that has come up before where maybe there's some education needed for the court here.
We can certainly discuss it. We can't accept
Yeah, it's not going to change the outcome of the vote. It's just that we've dealt with this issue, I think, before where we have individuals who are from the testing facilities that are providing interpretive opinions in these proceedings. I understand they're civil. We don't have jurisdiction, but I think it's certainly something that needs to be addressed. I think previously it was maybe coming up with probation or parole, and I think this one also comes from Harris County, so it's probably an opportunity for education for the judges there.
I think the best route for us to discuss that would be through OCA, since they have some role in training and education for the entire judiciary, civil and criminal. So I could definitely talk with our colleagues there to see if this would be something that they might like to pursue.
I think that'd be great. It's not going to change the outcome of the vote, but I'd hate to see this issue not be addressed and the judges to be educated on it. We clearly don't need people who are involved in the collection of hair providing interpretive toxicology opinions that have these types of outcomes.
I will speak with the administrative director, Megan Boy, about this issue, and they did actually, OCA sent me, there was an inquiry that came in about this to OCA, and they forwarded it, separate from this complaint, so I do think I don't know if there's a particular reason, but we're seeing that the concerns are bubbling up again. It's sort of a periodic ebb and flow around family law cases in particular, so I can talk with them.
Thanks, that's great. Sorry.
Motion and second, didn't I, on that?
Could you read it?
All right, we're gonna do this again.
Sorry.
Recommendation to dismiss because it's in civil litigation outside the commission's jurisdiction. Is there a motion?
So move.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
We have one additional staff dismissal, autopsy related that Dr. Bernard needs to recuse on. Again, we're recommending dismissal because the term forensic analysis doesn't cover that, and that is complaint 26.48.
Okay. We have a staff recommendation for dismissal of complaint number 26.48. Can I have that in the form of a motion?
So moved.
Can I get a second?
Second.
Okay, all in favor, say aye.
Aye.
All opposed? The ayes carry, the motion carries.
Yes, do I take that as a recommendation?
Yes.
Recommendation's been made to take a 10-minute break after that marathon. We're not voting on that, we're doing it. Let's get it going back on the record. We're recording. I'm hearing echo. All right, we're back on the record. We will start with item number 5, discussion of the status of the Crime Lab accreditation program. Lee?
For our accreditation related events this quarter, we've had 3 surveillance assessments, 2 reassessments of accreditation, 1 first-time assessment, and first-time accreditation by the Commission of a Forensic Biology Laboratory called Astria Forensics, and then 1 scope extension to include rapid DNA to a laboratory scope. And so if any of you have comments about those 7 accreditation related events or questions, let us know. We've summarized them for you. And then the second item here, B, is the summary of our proficiency monitoring non-consensus reports that we received from labs and separate out into this beautiful summary that Jara did for us, and research in depth each of these because some of them get really, really technical. We had, I think, 3 of the events that Dr. Kerrigan and Jara both consulted on to find out answers to questions that commissioners had and Dr. Kerrigan had, and I believe they've been resolved. Is that correct, Jara?
I defer to Dr. Kerrigan on that.
Oh, okay, yeah.
Yes.
Okay, great. All right, thank you all, and thank the labs for the responses on those. They're always super efficient and detailed, and we really appreciate the answers to those questions because they help us close out these matters. And we get a lot of the proficiency monitoring reports, as you know. We had 19 events this quarter, so I think there's no follow-up on those if you all want to move on, Dr. Bernard.
All right, next is item number 6, discussion of the updates from the Licensing Advisory Committee. Lee?
I just have a quick update on the licensing program for you all. Currently, we have 1,392 licensees. This quarter, which is quarter 3 in our state fiscal year, we're looking at the past 3 months. We issued 39 new licenses, which is a good number because typically we'll project about 60 new licensees per year. And this year, we really got a lot of new ones, and we do have a lot of those voluntary licensees coming through. So I think that is part of the reason why we've had more this year. Our 2 primary license types are regular licenses, which are just the mandatory and voluntary type licenses that are typically assigned to an individual. And then we have numerous of those non-interpreting de minimis type licenses, in fact 238 that take advantage of those license types. And the people that are licensed under that program don't make any particular interpretive type analysis, so they're typically in the technician disciplines and they're licensed at laboratories that perform analysis for a minimum amount of Texas cases. The other types of licenses that we have are the provisional, temporary, and regular uncommon, but you'll see on these slides that they are comprised of very small piece of the pie in the grand scheme of who we license in technically. Forensic biology, DNA analysts, I think we emphasized this last time, are the top category of licensure, and then the next down seized drugs analysts. And there's a significant or notable number more of the forensic biology DNA analysts than to the next level down, which is seized drugs, and then tox, of course. Right now we have 6 of those provisional licenses that They have a full year to be provisional and take the test or meet whatever requirements they need to meet. And then they have to get fully licensed and they can't ever apply for a provisional again. We have 8 temporary, which is typically like what you would think of as a pro hoc BJ type license where a lawyer goes to practice in a different state or help another lawyer out on a case. We have 8 of those, and then we have 3 regular uncommon, which is a laboratory that does like a type of testing that's not offered at a lot of laboratories in Texas, and so they essentially get licensed in a program similar to what we do under the de minimis program, so that we don't basically eliminate that service from Texas. One of the common examples is testing for feces in DNA, like a lot of our laboratories in state don't do that. So this lab licenses 3 people to be able to provide that service to TDCJ. Alright, so we renewed, this is the summary of renewals this year so far, quarter 1, 2, and 3, 320 licensees. 294 were analysts and 26 were technicians. We're projecting to renew through the end of the year. The end of the fiscal year is August 31, but through the end of the year we'll renew 296 more licenses. On average, we renew licensing staff renews about 49 per month. And the highest month that we're expecting or projecting renewal activity is December, and there's 69 in that month. That concludes my update here. Yesterday, the Licensing Advisory Committee met at 10 a.m. Some of the highlights from that meeting was that we reviewed the committee seats, and the commission will reappoint 3 of those in one of the next agenda items and appoint a new seat for the TCDLA seat. We discussed rapid DNA, which is also later in the agenda. Jared will address that for us in more detail later on in the agenda. We did give an update to committee members on the progress in developing our new exam, or the 3rd iteration of the General Forensic Analyst Licensing exam. We have a meeting with those who volunteered to learn how to item write or write questions for the test on August 24th, I believe. And we've also had a meeting with the psychometricians to finalize the study materials that we expect to see on the next iteration of the exam. We also addressed and voted on recommendations for the following rulemakings. Let's see. Well, should we go ahead and reappoint the?
I think we can go on to letter C, and then we'll just go straight down the list.
Okay.
So 6C on your agenda is the report of an audit that we performed after the retirement of our former licensing program specialist. Lee became aware that there was an issue with 7 licensees' exam grades, where there were 2 components to grading a general forensic exam. One is that the person has to make a minimum score of 70, and another is that they have to reach certain minimum numbers in each of the domains. And our former employee who retired had passed people who should not have received a passing grade. Of that group of 7 individuals who were licensed, 3 of them were in the mandatory licensing categories. In other words, they had to have licensure. One of that group was not doing criminal casework, however, during the period where she had been licensed. And then we had 4 in the voluntary license category. So of those individuals who were notified and retook the exam, 4 of them have successfully completed all 3 of the mandatory categories and 1 from the voluntary. The other 3 individuals within the voluntary category of licensure will be retaking the exam between now and December 1st, which is the timeline that we gave them. We did a root cause analysis, and we have the corrective actions in your materials. The root cause for the grading errors were, number 1, that it was a very time-intensive manual process. There was no automated process to do the grading, pulling the information out of Blackboard. And then we also did not have a second reviewer looking over all of the grades. It was being done manually by one individual. So we've corrected that. We have an automated Excel-based formula that Jara wrote for us and developed, so that we've integrated that and we're using it. We have second reviewers on all exam grades, and that review process is done at 3 different levels depending on the score that comes out of Blackboard is how rigorous the second review needs to be. So we have that information is in your materials. As soon as we get through the last 3 exams, we're planning to post this online on our website, just like all the labs post their corrective actions. So this is the first real root cause analysis and corrective action for an error that the commission has made that we've done. So it was painful but good experience overall, which I feel like describes a lot of this work in general. We're happy to answer any questions. Jared can talk more about the Excel tool if anyone would like to know.
All right, for item D here, we're gonna review the committee's recommended appointments and reappoint eligible members. We have 3 that are expiring that are eligible for reappointment: Dion Christoph, Lauren Woolridge, and Jessica Frazier.
All right, is there any discussion? Is there a motion to reappoint members Deanna Christoph, Lauren Woolridge, and Jessica Frazier?
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
For the second motion here under this item, TCDLA has nominated Nick Hughes, who we all have worked with, I think, in the past on the commission. So we're very grateful that he's willing to serve, and they've asked us to appoint him as a nominee.
All right, is there a motion to appoint Nicholas Hughes as the TCDLA nominee?
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
For E here, we don't have any motion or any activity to report. We like to keep this on in case right before the meeting we need a vote from you all, so that we don't delay anyone licensure. For F here, this is a rulemaking that you all proposed at the last meeting, and so this is the adoption in its final form, where we reduce the work experience hours or years required for firearms and tool mark examiners. And this was based off feedback from the community that 3's a sufficient number of years for them to go ahead and get licensed.
All right, is there a motion to adopt the rule amendments that have just been discussed, subject to suggested non-substantive revisions from the Office of the Governor, Texas Register and Commission staff? Is there a motion?
So moved.
Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
All right, the next item here is a rule proposal that you all have not seen before. It's included in your meeting materials. In the course of 2 of the investigations that we're gonna look at today, Robert and Lynn will go in more detail. We realized that one of the provisions in the Code of Professional Responsibility that requires individuals to communicate honestly and fully with all parties to particular criminal action, we didn't list also that they're obligated to disclose things like that to, or communicate honestly and fully with the commission as well. So we added that language there, we just added it. The commission is also included in that, since we're asking you all to propose this rule amendment.
We thought it was self-evident, but apparently not.
And it seems a little weird, you've got to actually write that out to make people understand. All right, is there a motion to propose rule amendments as discussed, subject to suggested non-substantive revisions from the Office of the Governor, Texas Register and Commission staff?
So moved.
Second? All those in favor say aye.
Aye.
Opposed? Motion carries.
For H here, we don't have any issues that weren't otherwise categorized as a self-disclosure or a current investigation, so I think we can move on to item 7.
Okay. Item number 7.
Agenda item number 7 is a rule adoption from a rule you all saw at the last meeting. Here, we're just trying to accurately reflect the scope of what the commission can do as far as investigative procedures. If you recall, staff can investigate, and also we can assign an investigative panel. So we're just correcting the title of the section there.
All right, any discussion on that? All right, is there a motion to adopt the rule amendments as discussed, subject to suggested non-substantive revisions from the Office of the Governor, Texas Register, and Commission staff?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Item number 8.
Item number 8 is a rule proposal that extends from an obligation, a mandatory ask by the legislature that is now codified in Government Code Section 41163B. It authorizes the commission to take disciplinary action against laboratories that don't comply with the new requirement to participate in the Clear Connect system by DPS. If DPS, basically what the rule says, if DPS notifies us that there's some issue of non-compliance, the commission can and may take disciplinary action in the same way that it would in an accreditation matter. So basically pulling their accreditation would be.
Well, we have lots of steps before we would do any such thing, so nobody freak out. But the first step would be to just contact the lab, send a letter requesting an immediate response and explanation for why you can't participate in the portal, and then asking the lab to outline the plan for participating in portal, setting a deadline for implementing the plan, and then notifying the lab what action we would take if you haven't done anything. So there's lots of steps before we would ever take any actual accreditation action. And in the first instance, it requires DPS to let us know that they're able to work through it with a lab. And so far, because of the outstanding work by the team, Kevin Callahan, who's here, and his colleagues, they really have done so much outreach on this. In fact, right after this meeting, there's a town hall for labs to listen to where we are on the portal and for them to take questions. And so I feel like I just want to make sure everyone knows that we are working closely to help the labs. We're brainstorming ways to alleviate implementation costs. We're really trying to make sure it's a smooth implementation.
Have all the labs been able to technically connect to this, or are there some roadblocks on their ability to be able to physically do it?
Well, there are different ways, different options that labs have to connect. And I can let Kevin speak to that, or we can put this on the agenda and update for next time, depending on the.
We're not gonna drag it out today. I'm just kind of curious if everybody's able to, so that it becomes a matter of unwillingness versus physically cannot.
So some people are able to do what we refer to as the gold standard, which is an API like direct connect. Others are using SharePoint, and still others we have like an interim tool that allows records to be sort of housed for 90 days, not permanently because the law restricts that. But there are different ways that labs can approach this and be in compliance. Is that fair, Kevin?
Correct, there's 2 technology solutions, and there's a transitional while laboratories figure out either the gold standard or the backup kind of idea.
Okay. All right, so were we through with that discussion?
Yes.
All right. Is there a motion to propose the rule amendments as discussed and subject to suggested non-substantive revisions from the Office of the Governor, Texas Register, and Commission staff?
Make that motion.
Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries. Next page, item number 9.
Okay, so for item number 9, we have been investigating a complaint by the Federal Public Defender's Office on a magazine mark comparison case from the Houston area. We have a draft of that and received significant feedback from practitioners within the firearms community, and so we're not going to adopt that report at this meeting, and rather we'll be continuing on to work on the report some more before the final adoption. And we think by October, we should be able to finalize it and adopt it. I would say that we did meet as the investigative panel met on May 27th. Those minutes are in the materials, so members of the panel, they can vote to approve those minutes. That would be helpful.
Well, there are only two of us that are involved in that, so. All right, I'm gonna make the motion to adopt the investigative panel minutes. Do I guess I have to get a second on that? Patrick?
I will second it, yes.
All right, all those in favor say aye. Aye.
Aye.
All right, motion carries.
And the second thing that we would like the commission's blessing on is to retain a subject matter expert. As you know, we have NIST, Henry Swafford and Steve Lund from NIST have been actively helping us on various firearms issues, including implementation of the VAST tool, and we would also, but neither of them are firearm subject matter experts, so we would like to retain the services of an expert to help us through some of the comments that we've received from the community and ensure that the final report is something that we can implement and something that will be helpful.
Will we need to then have a subsequent vote regarding the individual, or does this allow you to go ahead and make the decision on who to retain?
I think that this allows us to retain a qualified
Okay, I didn't know if we
expert,
had to do
and
the second
then
one.
it will be in compliance with procurement rules because there are certain state rules around retaining consultants that we have to comply with.
All right, is there a motion to direct staff to retain a firearms tool mark expert, subject matter expert, to assist the investigative panel with the final investigative report, including recommendations?
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Item number 10. I'm gonna end up having to recuse on this. So Dr. Drake, when they're done,
Okay, no problem.
I think this should be working now, hopefully. Okay, can everybody hear me with this microphone okay? All right. So this is the final report and a disclosure from SWIFT's. It says seized drugs there because we're required to define the disciplines, but we understand that this is not actually a seized drugs analytical or technical issue. It is an issue resulting from an employee, challenge with an employee who happened to work in the seized drugs section. So to summarize the disclosure, it relates to the credentials, the job-specific, education-specific credentials of a licensed seized drugs analyst at SWIFT's. Her license will expire next September 2027, and the summary of this is that she falsified her credentials on her CV that she submitted to the quality manager in January, and she said she had a master's degree when she did not. And after repeated attempts to get the backup for the master's degree, she was unable to do that, and then she lied both to her managers on multiple occasions and then during her mock trial, which is one that we have not seen until now. So the CV that she submitted to the quality manager for her qualifications that are obviously a necessary part of the work in the forensic lab stated that she had a master's degree, but she hadn't yet completed that academic program and she hadn't had the degree conferred. So they had asked for transcripts to back up the information on the CV, and she basically said that she'd get it to them and then she didn't. So she ended up resigning in lieu of termination in February of 2026. We let her know that we received the disclosure from Swifts and gave her an opportunity to respond, but she did not. We had voted to accept this at the April meeting, and she was also told that it would be investigated at that time, and she has not responded. She originally applied for her position back in April of 2025 and said at that time that she was in the process of completing her master's degree. The position did not have that as a mandatory component of the position, but Dallas County allowed certain qualified education to substitute for work experience, which is common, of course, when we're dealing with these types of positions. And so based on the claimed graduate work, she received a year of work-related credit under the Dallas County application, human resources process, and she met the experience requirement for the drug chemistry 2 position when those things were combined. In the summer of 2025, she said that she was due to complete her degree, and then the chief of forensic chemistry asked, like, can we get the transcript? She just didn't respond. There was a follow-up, and then she, even though she said she had the Master's of Science, she never provided the transcript. And they kept asking for updates, and finally they gave her a due date because she kept sort of, for lack of a better way to say it, blowing off the request. And on February 16th, she finally told management that she had requested the master's degree transcript, but there may be an issue with payment. And then finally, she admitted that she did not have a master's degree. She was dishonest when she represented her credentials on the CV that she submitted to the quality manager. And then just a week before, or about a week, 2 weeks before having made that admission, she engaged in mock trial training, and this was in front of supervisory staff and her peers, and she said during the mock trial that she had a Master of Science degree when she did not. And you know, mock trial, you're pretending to be under oath, so that was sort of astounding to us. You would think that at that point she might stop and say, maybe I should come clean on the fact that I don't have this degree. So the lab made a conclusion that she failed to comply with all the policies, the county, the lab, the accrediting body, the commission. They issued her a statement of non-compliance, gave her the opportunity to respond, and at that point she acknowledged that her failure to be honest about her credentialing directly related to the work that she does in the lab was a violation of various requirements. She admitted that she failed to be transparent, and what she really needed was extra time to finish her master's degree. She had a lot of anxiety and panic associated with the lack of confidence in the writing process, which was a component of completing the work, and instead of saying that up front, she sort of went along with it and ended up in a scenario where she was disciplined. So at the time when she, in February, mid-February, about around the 18th, she did express shame and regret for her conduct. She offered to revise her CV to accurately reflect her qualifications. And she outlined a plan to finish her degree and correct her actions, but she ended up resigning in lieu of termination on February 20th. So we looked at the definition of professional misconduct, and it includes acts or omissions that would substantially affect the integrity results of the forensic analysis. And in this case, given the fact that this is your degree that is in support of the work that you do, we agreed with the laboratory that the act of falsifying a job-related educational credential would call into question her integrity, as well as the integrity of the forensic analysis, and that she did commit misconduct when she deliberately falsified her job-related educational credentials on the CV that was submitted. And if you know anything about an accredited lab, like that CV carries other implications because your qualifications are supposed to be clear, and certainly not fabricated when it comes to the forensic analysis that you're doing. All of that has to be substantiated. We note that she committed some professional responsibility, code violations. It expressly says that you have to accurately represent your education, training, experience, and areas of expertise, and document and notify management of adverse events such as unintended mistakes or breaches of ethical, legal, scientific standards or questionable conduct. And by failing to acknowledge that she hadn't achieved the degree at the outset and sort of continuing on with the misrepresentations, she failed to make that notification in a timely way. So there are some aggravating factors, which were the continuance of the misrepresentations, and also we think it's important that she made these representations during a mock trial exercise when she was put under fake oath, but still, we understand what the purpose of those exercises are. She was dishonest with management multiple times. There are some mitigating things. She has no prior conduct history. She ultimately did admit the representation. The recommendation that we have, however, because we don't think that it's going to be possible for her to recover from having lied during mock trial about her master's degree or having lied multiple times to management, is revocation until the expiration of her term, which is September 7th of 2027. That's all we have for that. Does anyone have any questions? Yes.
Do we know if she was actually enrolled in any classes at the university?
If she was ever enrolled, Robert?
If she was actually in a program, or did she say
I think
was
she
just working on her
was
master's?
was she in the program? Yes, we think she was, she just didn't finish.
Okay.
I don't think she lied about participation in general at VCU, but she certainly didn't finish.
I don't think it's important for the report, but did anyone from the commission actually reach out to the program director at Virginia Commonwealth University about this?
No, but we can.
I think it probably wouldn't hurt.
Okay.
They're
What are you thinking,
almost
Dr.
certainly teaching a course in QA and ethics where they address credentialing and the code of professional responsibility. And so I think it would probably be, it might be good to point them to the final report.
We will. Can you make that note, Robert, to make sure I don't forget? And then if you all have contact information for VCU, we can get with you, Dr. Kerrigan, to make sure that we have the right person.
I don't think you should hold up the decision on this. That may be in your final report, but I don't see why you.
Yeah, it doesn't need to be in the report. It's just as an FYI.
Yes, we will do that follow-up, because I do agree that they probably would want to know about this. That's all I have, Dr. Bernard. We do have there is a recommended motion.
Right. Dr. Drake's gonna need to.
Dr. Drake, whenever you're ready.
All right, thank you. Staff has made a recommendation to accept the final investigative report in disclosure 26.18. Can I have that in the form of a motion?
So moved.
Do we have a second?
Second.
All in favor, say aye.
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 All opposed? The ayes have it, motion carries.
All right, next is item number 11. Because of this, I may have to recuse as well.
Yes.
Yeah, all right, because of the ultimate location. So Dr. Drake, you're gonna have to work again on item number 11.
Okay, so this is a report, unfortunately, also on a conduct-related issue. And again, this is a human forensic biology analyst, but the issue here is not related to the actual forensic work product, but rather administrative timekeeping. So the summary of the disclosure is that this individual is a licensed forensic biology analyst, and she has worked at 3 different places, and all of those become relevant when we go through the contents of the report. She started at DPS in Waco, and then she went to Othram, and then to Swifts, and that last part is why Dr. Drake will be taking the motion in this case. But what the report discusses is the fact that the analyst had some sustained administrative findings by the Office of Inspector General at DPS regarding her timekeeping practices, and that information was not shared with subsequent employers. So that would be both Othram and Swift. So initially, DPS had disclosed to the commission and to stakeholders the fact that they had forensic analyst with sustained findings by the Office of Inspector General related to timekeeping. And after that time had passed, after that initial disclosure, and we became aware that there was a suspicion that she had not shared those sustained findings with Othram or with Swifts. This particular analyst's license is due to expire in October of this year. So we had reached out to Swifts to ask management if they were aware of the fact that when 2 employers ago, this person had a sustained finding by the OIG, and Swifts was unaware of that information. They asked the analyst, and she said she didn't realize she needed to share that information. She submitted an email explanation to the commission about her perspective on this in the beginning of April, so on April 2nd, and then she submitted a second supplemental response on April the 8th. The commission voted to accept the disclosure for investigation. By that point, we had requested and received the full OIG report, which outlined the extent of the timekeeping issue that they had investigated. We interviewed the analyst herself June 30th, and then on July 1st, we spoke with her former supervisor at DPS in Waco. July 8th, we spoke with her former supervisor, who also was very involved in her hiring when she was at Othram for a brief period. So back in June of 2022, this analyst's coworkers at DPS in Waco raised concerns about whether she was working the number of hours she was claiming to work. And they started comparing the paper timesheets that she turned in, her CAPS entries. CAPS is the state timekeeping system that all state employees participate in. We're all required to have accurate entries in CAPS. And they looked at the sign-in sheets and noticed some discrepancies. And they spoke with her, and her explanation was that she just used the pre-populated timesheets and did not adjust them for the time that she wasn't actually in the office. And then the management investigated further. They looked at the badge entries in and out of the lab to see when she was actually present and when she wasn't. She did not do the type of work that was conducive to remote work, and so they looked at all that record keeping, and they met with the analyst again in about July 25th of 2022, they advised her that the OIG would be conducting an administrative review and possibly the Texas Rangers would also be investigating, which is what would happen if it was perceived as a criminal violation. During that meeting, the Waco Regional Lab Manager shared that, and I just want to be really clear about we are summarizing this based on notes and files that the OIG has from that time period. But our understanding is that she said, although I can't be sure what is going to happen, I can tell you that based on my experience, typically the way these timekeeping issues are addressed is, one of three things can happen. If the OIG sustains the allegations that you have these timekeeping violations, it usually leads to termination. And then if you resign before the investigation, the employment history in caps would indicate resign because nothing has happened in the form of an investigation. If you resign during the middle or toward the end, the employment history may indicate resignation in lieu of termination in caps. And I did not realize there were all these categories in caps, but apparently there are, depending on what stage you leave, the caps reason for departure or separation from the agency may be different. So she resigned essentially immediately. She resigned her position with an effective date of August 10th. And then some time passed and she ended up going to Othram. So to give some background facts about that process, even before she left DPS in Waco, she'd been looking at opportunities at Othram. And in May of that same year, she was exploring an opening that they had, but in early June, that position was filled by Othram with a different candidate, not her. And then after she resigned from DPS, about mid-August, Othram emailed her about a new opening, and she started working there in October of 2022, but her offer was not made until well after she resigned from DPS. Now, there are some differing recollections about whether she revealed the existence of the OIG investigation or the timekeeping issue. She recalls having spoken with her Othram supervisor about it, but the Othram supervisor does not share her recollection that they had this conversation. Her former supervisor in Waco did speak with the new Othram supervisor, and he recalls informing her of significant timekeeping issues. Her perception from the conversation was that the issues or concerns were more limited, that she'd been taking long lunches, but the issue had been resolved internally. I will say that all managers with whom we spoke have indicated that the quality of her work was good. She's a talented forensic scientist, which makes a lot of this even more difficult, I think, as we were going through it, because she's a skilled analyst. Everyone agreed. No one said that they had concerns about her performance in terms of her technical competency. In September of 2022, the OIG issued a report where they basically found that between March of 2021 and July of 2022, there was a 279-hour discrepancy between claimed work hours and actual time worked. 96 of those were requested overtime hours. So we didn't have that information until we got the OIG report, but that's a lot of hours. I think it goes without saying. And then, but once that OIG piece was finished, DPS did what they always do, which was they have their disclosure forms, and they created a disclosure form for her, and they sent it to her at Othram, not at a personal address, but at Othram. So she received that in early January 2nd of 2023. And when we spoke with her, she conceded that she didn't disclose the results or share a copy of that disclosure form with Othram when she received it in her email, and then subsequently when she went to SWIFT, she also did not share that she had this disclosure form. when we looked at her renewal application, she gave her reason for leaving DPS another job opportunity. And while it is true that she had generally been exploring other opportunities with Authorm, she did not have an offer at the time that she said she left for a new job opportunity. So we have some observations and findings here, which is that this is something that before the legislature changed our statute to allow for disciplinary violations, specifically for Code of Professional Responsibility violations, we tended to only suggest disciplinary action if there was professional misconduct directly related to the forensic analysis. Because even though a violation of a rule or order of the commission could also lead to disciplinary action until the legislature made it clear that these code violations were part of that, we were sort of reluctant, I think, to move forward with disciplinary actions without that express statutory authority. So between the time that DPS disclosed the administrative timekeeping issue until we realized that she was not forthcoming with her subsequent employers, the law changed. And so what we would submit is that we think in looking at the way that professional misconduct is defined, it requires that a forensic analyst, through a material act or omission, deliberately failed to follow a standard of practice that an ordinary forensic analyst would have followed, and that act or omission would substantially affect the integrity of the results. So while we absolutely think that this is clearly impeachment, it is a step removed from the actual forensic testing and interpretation. It does not involve her job-related credentials. It is something that previously we would have considered to be administrative, truly administrative. And the quality of her work has been good. However, if you look at the Code of Professional Responsibility, it's quite clear, and we train on this extensively, that analysts must document and notify management or quality assurance personnel of adverse events like ethical breaches and so on. And we believe that an OIG sustained finding of this nature falls within that category, and that they need to ensure proper reporting to all scientific and legal parties of any adverse events. And so here is where we're expanding our rules to make sure everyone knows that that includes the commission. So you need to be honest with the commission in your license application and give a fulsome report of any of these types of issues. Now, we can say that generally speaking, people who are applying for renewal over-disclose. They disclose all sorts of things that we routinely say that's not an issue that we are concerned about. A lawsuit, a big lawsuit in civil litigation that names everyone, all of DPS and so on, that to us is not going to be something that we would ever hold a license back on. But these other things like sustained OIG findings are certainly impeachment. So what we're suggesting in the report is that the analyst receive notification, which she concedes she did receive, of the results of the OIG investigation in early January, so January 2nd of 2023, and her immediate and ongoing obligation was to let Authorm know of the adverse event so that they could ensure reporting as needed to scientific parties or legal parties or whoever needed to know that information, and that she was also obligated to inform SWIFTs of the matter because those obligations are ongoing and we teach that. She did not testify while she was at Authorm or at SWIFTs because she was only recently signed off for independent casework. But lab management still needs that information. They need to understand what the history of their analyst is, both during the hiring process and then later, to ensure that people are prepared to testify about these issues and so on. Her license renewal stated that there was a new job opportunity, but we think the timing is a little bit off for that to be the only explanation. We don't think it was a comprehensive or complete response. And when we were talking with her during the interview, she acknowledged that. And then we believe, and what's in the report is that the violation is the failure to disclose the results to Authorman Swifts. There was a poor decision not to notify the labs that the impeachment material exists. And it really compounds the previous poor judgment related to her timekeeping issues. In terms of mitigating factors, she has no prior conduct history with the commission. She accepted responsibility when we were speaking with her for the timekeeping issues when interviewed by OIG and FSC staff. She expressed that she was under a misunderstanding about how long the obligation to disclose sort of follows her. And as we've said before, there were no technical issues with her competency. So our suggestion is that her license be suspended through the last day of her expiration, and that if she were to apply to renew her license, she has to document and submit successful completion of remedial training and legal disclosure compliance, including how she will have to discuss these issues with stakeholders, as well as what one of the big emphasis here is understanding that the obligation is ongoing. So that's what the report has in it. We have some other recommendations in this report that we discussed at the TAPLET meeting yesterday, which is that labs should consider reviewing their hiring processes to more thoroughly screen for potential disclosure issues that may not be covered by the run-of-the-mill city, county, and state applications. And we also looked at our own process and application questions and expanded our questions to ensure we cover all sorts of conceivable disciplinary or adverse events. And then we suggest that the TAPLET might consider model application questions that would be helpful to share, because not everyone has. Some of the labs have amended their applications to have sort of special forensic science specific screening questions, but not all have. So if they could share that information, it would be helpful to have that among the labs. So this is our new question that is in the licensing application, which is, are you aware of any pending or completed investigation against you for professional negligence or professional misconduct or violation of the Code of Professional Responsibility, which we link there, or any current or former employer's policies and procedures? So we're trying to cover lab violations, code violations, negligence, or misconduct, whether pending or completed, finished or started, et cetera, et cetera. So any questions, comments? Dr. Barnard will not be able to participate, so Dr. Drake, if there aren't any questions or comments, if you want to take it from here, that would be great.
No problem. We have a staff recommendation to adopt the final investigative report for item number 26.18, which includes a suspension of the analyst's license through September of 2026 and other recommendations. Do we have that in the form of a motion?
So moved.
All right. Do we have a second?
Second.
All in favor, say aye.
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 All opposed? The ayes have it. The motion carries.
Thank you.
All right, item number 12 is the update regarding statewide firearms working group.
Had a couple meetings in June and July, just going over system testing, and now we're starting to look at the report, what it's gonna look like. Pretty interesting. It's detailed performance metrics. We now have a one-page executive summary that's part of it. We're also trying to make sure all the laboratory SOPs are using the same method. That's something that we're in the process of doing. We have almost all the laboratory SOPs gathered, and this is going to help us with that review and also review of ASB standards. See if we can find a one method to go forward. That way they can share that in the VAST tool rather than being on the island by themselves.
Anything further? All right, item number 13, rapid DNA.
Briefly, we had a meeting in June as the statewide working group on rapid DNA. We're continuing to move forward on preparing some documents for the type of guidance we want to give to rapid DNA operators and collectors for these crime scene samples. An important thing that happened recently here at the beginning of July where we kind of been working without a platform that's approved by NDIS, which is what would be necessary to actually put a DNA profile into CODIS for searching. There is now an approved platform, the Rapid Intel Plus cartridge for those crime scene samples has been approved. So there's a system available now. So it adds a little bit more, I think, impetus to us to complete some of these initial documents that we have for the sample selection, which will be supported by a lot of the work and the validation that Dr. Letts is doing at DPS. We also have modified a memorandum of understanding, which will be vital, I think, with these partnerships between the DNA laboratories and the law enforcement partners. And of course, we will continue to work on building out a licensure structure for the rapid DNA operators. So all of those things are on the agenda for our next meeting together for this working group on September 11th. And that's, any questions about that, I can certainly provide more information.
All right, no further discussion. Item number 14.
So item 14 is the forensic apprenticeship the forensic analyst apprenticeship pilot program. And what I wanted to say first is that applications to labs for that is sort of the first part of what we are trying to move toward, is to ensure that people who are interested in having an apprentice, and it would be, right now we have 3 different disciplines: seized drugs, alcohol toxicology, and human forensic biology, so DNA analysis. In particular, interpretation being the focus there. We will be, thankfully, Dr. Stout and Brady Mills have been speaking with the labs to try to get a sense of what their needs are and how to fairly divide the apprentices among the labs to address their needs. One huge gaping need that we are still working on trying to fill is firearms. We definitely need a lab a university partner who can take on that work. IFRTI at Sam Houston is, in terms of the curriculum development, they are the furthest ahead on seized drugs and alcohol toxicology, where there is a full-time project manager as well as course design folks who are working on the various modules that will be needed to educate and train the apprentices under those disciplines. And UNT Health, the CHI, they are working on, they already have some curriculum due to the fact that they have trained DPS on some of these concepts over the years, working on, I believe they recently posted a new update to their project manager description, and they're working on hiring somebody to spearhead that. OCA has assigned Neetu Gill, who's a project manager for OCA, to ensure that we're developing benchmarks and timelines and hitting those milestones, so that when we go back to report to the legislature, we have some concrete progress to report. So that is what I have on apprenticeship. Does anyone from either Dr. Coble, CMAC, Dr. Kerrigan, does anyone want to add anything to that report? No? Okay. That's everything I have there, but this will be a standing agenda item for sure.
All right, item number 15.
So the main issue here is that we have another big DNA training for lawyers and judges coming up at the Capitol. And so far we have about 120 people registered that, a combination of law enforcement, lawyers and judges, both defense and prosecution. We have a very extensive agenda for that, where we're trying to touch upon all the key trending issues in forensic DNA analysis, as well as interpretation, reporting, and testimony, and how all of those things interface with the criminal justice system and at trial and post-conviction. We have an exoneree who will be featured from Bexar County, who had DNA as a key element in his case. So we're very excited about that, and we encourage anyone and everyone who would like to sign up. It's on our website, whether you're law enforcement or forensic scientist, lawyer, or judge. We really want to see as much participation as we can get, because it's a great program, and it follows on one that we had done a couple of years back at the Capitol. So we're excited about that. It's going to be an intense 2 weeks leading up to that. It's co-sponsored with CALE, Center for American and International Law, which is located in Plano, but they will go and help support through the Court of Criminal Appeals grant for the training of lawyers and judges. So they will be here at the Capitol for those days. And we will have CCA judges there. We'll have all different levels of folks, different experience levels, prosecutors, defense. So we're excited. And that's coming up in August. And you should have the agenda for that in your meeting materials.
All right, item number 16, report from the DNA Technical Leader Working Group.
Yes, this is another standing agenda item to just give you guys an update on the progress of what we're doing in these meetings that occur generally every couple weeks. With the selection of either DNA technical leads from Texas accredited DNA laboratories or their designees. Recall October 2025, it was my first meeting, I believe, on commission staff. We adopted some reporting concepts, and those have been posted on the website shortly thereafter. And we've gone through a lot of iterations of the type of work product we want to do, with a lot of really great conversation and then some, in-person meetings there in the middle. But our recent work product is in your materials, and it is not final, it is a draft, and we are still working through the wording and the comprehension, the consistency of how this is formulated. But we wanted to go at it as a frequently asked questions document, because we did get some questions about some of those reporting concepts, and we felt like it might be helpful if we gave a little bit of information. So that's what that section 1 is in that document, are sort of some follow-up questions that we've received with some information to consider for each of those 5 reporting concepts. And then the second section is everybody's favorite topic when it comes to DNA transfer and those related factors. Is really just a nod towards some general education and understanding with some citations for readings if the reader is so inclined. And then the third section is trying to go in a little bit more detail just for defining what has really, I think, taken over in terms of the jargon in our space, which is ALE, or activity level evaluations. So right now we've got a few questions that are like, what is this thing called ALE? And do you do this here in Texas? And why aren't you doing it? And things like that. So that's the general direction of what we're a resource for the community, especially our lawyers, that they can go and have something that's helpful, maybe the scientists can give out. So does anybody, any commission staff or members have any questions about that?
All right.
If you have feedback on this, please provide it. And for the lab directors who are here, the people who you send to those meetings should be taking this document back for input. Hopefully that's happening. If not, maybe ask or sort of jog their memory that they should be doing that, because we will finalize it and then it will be handed out to lawyers, judges who wanna understand what it is that the labs are doing, what the status is, what they can and can't, or not can and can't, what the existing forensic methodologies, say and don't say, or how they can help answer certain questions or not, because there might not be enough information to answer questions, even though they may be questions that everyone wants to know. So that's the purpose of this document, so please review it.
All right. Item number 17, update from Texas Association of Crime Lab Directors. Dr. Stone.
Good morning, y'all. So we met yesterday. Most of the items that we discussed are already updated here. A couple of things that we had. We voted on new officers. I've been reelected as president. When was yes, you're stuck with me for another 3 years. I saw that smirk.
I got my phone to keep time.
Yeah, but did you have something to throw at me if I go over? Don't answer that question. Wynn was reelected as secretary and Emily was reelected as treasurer. We had some discussions about particular quality management software that many laboratories in the state use, as well as issues with some of our LIMS vendors. Those are things we'll need to be following up on kind of a more coordinated effort, particularly as they pertain to all of our interfaces with the state portal. Otherwise, legislative stuff is starting to already pick up as we head towards the next legislative session. The Forensic Analyst Apprenticeship Program is on the list of interim session items from the Speaker of the House. Not heard about any testimony yet or anything there with that, but expect it might be out there someplace. I've also had conversations around the expectation that THC cannabis is gonna be a thing again this time, as well as kratom or kratom, depending on who you talk to, and regulations around 7-hydroxy. We'll see what comes with that. There seems to be a desire to want to try and do something that could be interesting. So that's what we had in our meeting yesterday. Any questions I can answer for you from the library community?
Any questions?
Thanks, John.
Thank you. All right, item number 18. Are there any matters that a commission member wants to direct the staff to place on the next meeting agenda?
I don't know if this would be on the next agenda, and so I'll leave that up to Lynn, but I know that the Texas Tribune just came out with an article just talking about possibly new laws about THC as of yesterday, and Delta 8, Delta 9. So I don't know if there needs to be an update or something like that, but I know that their prosecutors just kind of wanting to know kind of where the commission is, or is the commission aware about that? So the next meeting in October, we may want to have something on that.
We could definitely ask Dr. Stout for a more extended update about what we expect to see.
If you're gonna invite me for a rant about that?
If
I
you
don't want
want,
to invite, but you know, we may have to invite him, unfortunately, so.
Yeah, but if we don't really know what is going to be proposed, are you asking if you could have a discussion about what is potentially being proposed?
I guess my argument is that I haven't done a ton of reading into it. I know that law enforcement is talking about laws that should be going into effect as of today, July 31st. So, and I'll shoot the link and put it in the Zoom chat so that maybe I'm off base here, but it is about Delta 8 and Delta 9 and what's legal on July 31st of 2026 now. So that is kind of my concern. And so that may be something of interest to the crime lab directors, but also to prosecutors and who are watching, as well as defense attorneys who are watching.
Okay, Dr. Stout.
So yeah, as of today, the Department of Health and Safety rules. So they had proposed rules, they went through a public comment set period. Those promulgated rules go into effect today. They affect Delta 8, Delta 10. They're impairing hemp products other than the hemp flower. Hemp flower is still under an injunction. There was a lawsuit around hemp flower products. So what these are is things that have Delta 8, Delta 10, HHC, you got the other things other than Delta 9. So Delta 9 still is, dare I say, legal. I'm not even sure I know what that means. But in low dose products, Delta 9 is still allowable. How about that? So now how these things are actually going to shake out, I can't tell you. And it's going to be, again, this mess across the state. DPS, I'm sure, is going to really suffer with it because they're dealing with jurisdictions that are going to want to try and do something in jurisdictions that don't. And I don't have a good answer for that.
DPS, do you have any thoughts on this?
No, we're waiting we'll give our client base and kind of see kind of what their reaction to Delta 8 and Delta 10 is. That is the change that goes into effect. So timeline wise, they're starting these original things the health department did back when legislation occurred. They're starting to work themselves through the process. And so the changes today are Delta 8 and Delta 10.
So Jarvis, did that answer, or do you want the commission to have something more substantive regarding what the potential impact is?
I think it could be even a 5-minute update, and then maybe Robert, I don't know, in October, I think that would be good for people to just to have, and I know an update on my side with prosecutors and with law enforcement, because there are a ton of these facilities that are out there selling Delta 8 and Delta 10. Prior to that, I think that would be helpful, even if it was 5 minutes.
Okay, we'll add it to the agenda for a more extensive update than what we normally get from the tablet. But this is, we always cover it, but we probably need something.
Yeah, we can start with that, and then if it turns out that there's still a lot of questions, it may be that the commission has to have something a little more formal for
Sure.
education for the attorneys.
Okay, sounds good.
And not just that, but also it might be good to understand from Brady or from TACLID on what the impact for the labs will be, because this sounds as if it will have more than just legal challenges.
Also explode the amount of cases going to the lab right now. So if that is true and Delta 8 and Delta 10 are illegal now, the amount of cases probably will increase.
All right.
Thank you.
All right, item number 19 is the schedule of the future meetings, which will currently are October 23rd, 2026, January 29th, 2027, April 30th, 2027, and July 30th, 2027, and October 22nd, 2027. Is there any discussion regarding those dates? Is there a motion to direct the staff to schedule these?
So moved.
Is there a second? All those in favor say aye.
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 Opposed? Motion carries. Item number 20, is there any public comment? Anybody sign up? Hearing none, then is there a motion to adjourn?
Moved.
Is there a second?
Second.
All those in favor say aye.
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 Opposed, which I doubt. Motion carries, meeting is adjourned. Y'all did quite well through that massive,
I put my contacts in. Trying to see really well. Okay, now I can't, I'm just like looking. Hoping to catch